Ready, start. The pith and substance of the allegations set out in the complaint filed by Bansidhar Annaji Bhakhad was that there was a dispute between him and Ismail Yusuf Junior College, a state government educational institution where he used to serve as a lecturer. His services were terminated by the college with effect from 1st December 1993. He instituted suit number 1204 of 1995 against the college by invoking the original jurisdiction of the High Court, seeking damages to the tune of rupees 43 lakhs from the college. Owing to an increase in the pecuniary jurisdiction, the suit was transferred from the High Court to the City Civil Court, Bombay. The college thereafter filed a chamber summons in the suit seeking amendment of its written statement. Certain documents were annexed with the chamber summons, which were supported by an affidavit. It is further alleged that the advocate on record, Sri N.P. Pandit, certified the documents filed with the chamber summons as true copies. As per the complainant, the respondent advocate identified the deponent of the affidavit filed with the chamber summons, and in doing so, she purportedly attested to the correctness of the contents of that affidavit and the chamber summons as being of her personal knowledge. As per the complainant, the statements set out in the affidavit were ultimately found to be false, and therefore the respondent advocate, by subscribing to the affidavit, had lent support to the false recitals and made a false deposition based on the contents of the affidavit. The gravamen of the case as set out in the complaint was that the respondent advocate could not have identified signatures of the deponent without assuming responsibility for the correctness of the statements contained in the body of the affidavit. As per the complainant, the deponent of the affidavit made incorrect statements and filed false documents, and thus the advocate who identified the deponent by appending signatures on the same would be equally responsible for the offences of forgery, perjury, or cheating. The respondent advocate filed the subject writ petition before the High Court, and the High Court, upon consideration of the material available on record, held that the respondent advocate at no point of time had sworn any affidavit in the suit, motion, interim application, or the chamber summons. The mere act of identifying the deponent in an affidavit filed with the chamber summons would not make the advocate responsible for the contents of the affidavit. The High Court found the allegations set out in the complaint to be wholly absurd and untenable. In our considered view, the said finding recorded by the High Court is perfectly justified and hence unassailable. An advocate, by mere attestation of the affidavit, does not become a privy to the contents of the affidavit. Hence, ex specie, the complaint filed by the petitioner Bansidhar Annaji Bhakhad against the respondent advocate was not only bereft of substance but was also founded on malicious and spiteful insinuations directed against the advocate, who merely identified the opposite party in an affidavit.